Your Lordship, in the meantime, I overlooked a couple of annexures while submitting the written arguments. I'd like to submit it. It's just 2 pages only, Your Lordship. Just 2 annexures which I had referred to in my arguments. I have not been able to overlook in Karnataka and in India. And without that, I cannot make a claim against restitution. Yes. It is all referred to. No, to take judicial notice, one, and secondly, in accordance with the requirement to file a certificate under Section 65B of Evidence Act. Pen drive. Yes. Your Lordship, just some chart, 2 charts only. That's all I must say. Humble request. Okay. Your Lordship, also there is one tangential question I did not answer the last time. I was asked a simple question, just a tangential question. What I do, I have published a book, primary author, which is in the High Court libraries here, Karnataka, all 3 libraries. It's on arbitration, the first book of its kind. And the reason I mention this is also Kerala High Court. I lectured before the National Judicial Academy. Justice Mustafa ordered a copy, as well as Orissa and Supreme Court judges also have copies. Now, in that regard, I just want to mention, in wrapping up, my written arguments clearly make a case out for development of the law and harmonious interpretation by this court, just to, in terms of the seminal cases that have been referred to, the development of the law and judicial, what I must say, discipline, which is very much welcome because you have so many Supreme Courts. So my case is basically answers the question: was there a contract between myself and the respondent? The answer is, I made out a case for claiming the excess payment for rental as well as the repairs and costs. All of them I have referred to in a very chronological fashion, and it is very easy to read. More specifics are given in tabular form as to specific exhibits, to just reiterate and reinforce that there was every opportunity given to the architect as well as to the defendant, more importantly, to come and cooperate and take measurements. No measurements were ever taken up until the time I have proved that in my case, till the expert opinion of Rangnath and Associates, who was the secretary of the Consulting Civil Engineers of India, Bangalore chapter, and is also chartered engineer in value, a master's in USA, master's in India in structural, and then subsequently by the court that selected out of 4, 1 expert opinion, that of Dr. Srinivas Murthy, PhD, emeritus professor and consulting engineer in Indian Institute of Science. Now, every step of the way, every effort, reasonable effort, was made by way of written communications, which are shown as exhibits, to the defendant and the architect to cooperate with us before we came to the court. Since they did not cooperate, we sent a legal notice. Certain clarifications were required as far as Rangnath and Associates were concerned. Those were further looked into because of lack of cooperation. Rangnath and Associates were in fact contacted by the respondent contractor, but he refused to cooperate, saying, you go ahead with it and do whatever you have to do. And when we found there was an excess, we communicated to the other parties through various exhibits. Now, as far as the impugned trial court judgment is concerned, a number of points have been raised by the honorable trial court, saying that this is an expert, including that it's an expert opinion and a highly technical subject, which is a fact. Yet he has poked his nose into measurements not taken here, there. I'll give one very simple example. He says measurements were not taken of the thickness of a chajja. A chajja is an extension above the window, which has a fixed thickness. The thickness can be given in the drawings, the working drawings, which are, say, 3 inches thick. On top of that, there is what is called screed flooring. Screed flooring is nothing but batani jelly, as we call it, very tiny 2-3 mm or half inch jelly, which is sloped, and average thickness of 2.5. Above that, there's a plastering. Below that, there's plastering. So if he says he's not taken a physical measurement, the court cannot go into it and say, you don't know what you're doing. So a number of examples have been given, which I've refuted per contra, that there are false statements of facts. False statement of facts by the court itself. No, I have to grapple with that issue as well. And anyway, that is the reason for the lengthy explanation, and it is very clear. Each and everything can be corroborated with the evidence on record, and also this inferior quality material that has been put into it, and yet he has claimed for excess rates. He himself has billed in his billing for lower cement rate. Then he comes in after the final bill issued and after receiving legal notice that there was an enhanced cost of cement. I've compared that with local construction works in near Yelahanka, near Hebbal. In fact, it was lower. We had a higher rate for the concrete, which was fixed in the part of as part of the tender in the last page, as you can well see. Then there was the other issue of what is this concrete, unfinished concrete structure, 10, 12 photos showing how he has left the site because he couldn't collect any more money from me. The first bill was done in around 3 months. Second bill came after 11 months, despite persistent attempts to get it from him. And then he delays the project so he can collect more money. And that reason also is given. He had actually given a timeline saying he'll finish it within a reasonable time of 10 months, provided other items of works were also completed. That I fully agree. Yet his own civil into section 1718, which is fraud, misrepresentation, and section 19 of section 1718, which is fraud, misrepresentation, and section 19 of the Act of the Contract Act in relation to free consent under section 14, then definitely it can be avoided. And I did so by written communication. He even claimed that I had not paid him money on the balance on the final bill after giving final bill. On top of that, he comes in subsequently with an additional bill. So his counterclaim also is not in order. This is very much the case that I have made out. I have shown where he has pointed out to apparent defects by the commissioner's report. Even there are falsehoods. I have pointed out where actually the commissioner has shown item-wise and page-wise in his report, they have been included. He says there are some missing doors, there's missing overhead slab, there's missing beam here. Each one of them have been noted there. So it's just like filling out as much paperwork as he can. If you look at his bills and you compare the report of the EC, that is the engineer commissioner, you'll find here in a very flowing hand, he has just written in his bills. You don't know where he's taking these measurements. You don't even know which part of the building he has taken these measurements, all packed into one bill. And he claims falsely in his memo of appeal that only 3 bills had to be submitted. It does not say that. The tender clearly states running bills and final bill, like any other contract. But he claims it was stipulated there are only 3 bills. So if he makes these kind of fraudulent claims, I have every right to claim whatever is due to me. Even if there was not a written contract, if he had done the work, quantum merit, whatever he may deserve, that could have been given. And what the work of the engineer commissioner was exactly that. And he has pointed out very clearly where the mistakes came, how they came, and how they were unexplained. Alterations, modifications were all included in all 3 bills. Yet he comes back and says there were further bills pending before the architect. You go to the architect in his reply notice to my legal note points, which the engineer commissioner points out in cubic feet, square feet, etc., where there are tabulation errors. How could you have manufactured such a signature on something that has been given to him blindly? When I went to the Council of Architecture in New Delhi, it was very clear. They read the report of the engineer commissioner, that of Ranganathan Associates. They cross-examined both. I mean, we went before. He brought a lawyer. I was there in person, and we examined each and everything. The technical committee agreed, and that there was falsehood, and they chastised him for not taking measurements on the building at the time of the construction. So where was the question of him actually measuring anything? He never. They say you never kept final measurements. You are disciplined under professional misconduct rules. The disciplinary committee looked at it. The council looked at it. They applied their mind. They said so. The exhibits are there. And he himself has provided an exhibit saying that he was disciplined. Exhibit D as in David 40 in his D series. Now, as far as IA number 1 is concerned, it is about the rental matter. Now, the trial court in its infinite wisdom somehow came to the conclusion that he has falsified the case. That is the GPA holder of the owner of the building which I occupied with my family. So I have provided mother documents, which I was able to unearth much later. It shows that my father had rented it, but he had the right to sublet it to me. And I've paid checks, which are part of the exhibits on a regular basis. This correspondence as marked as exhibit where the GPA holder, Mr. Syed Moeddin, says, I have informed the contractor that I need to be vacating the house, that's myself, and to do it, and that you knew that I had to leave the premises up to in 1999, which was part of the lease agreement, which I had, which for about 8 months he delays putting tiles on my sloping roof after it is finished, and even that is in the working drawings. He gives no reason why he has not put the tiles. Well, what is the reason for? Usually you put the tile within 3 weeks. He has taken 7 months. These are all intentional and avoidable delays. May I continue? As far as IA number 2 is concerned, it relates to the fax communication I sent in great alarm to the Chief Justice at the time and the administrative judge, saying the judge in open court is threatening bias and he's threatening to ruin my case, and I wanted to have it transferred. The number 3, I wouldn't do that just because I wanted to, unless my lawyer had to. 2 of my lawyers told me that. And number 3, IA number 1 of 23, that's the third IA, it relates to his claim that he started work prior to February 3rd week. The timeline he has shown is from February 3rd week. Now, if he has started work prior to February 3rd, and he has made a claim against me, I have to have some way to find out where he would have put his records. I did. I thought about it. The Karnataka state the Karnataka Commercial Tax Department now, Sales Tax Department, he has not at all submitted any records of my house, yet he bills it on his proprietor concern, Puja Construction. This is a commercial establishment. And they raided him twice in 2004, but my project started in 98, 99. So if he had started work on my project prior to December, I filed a right to information application, and the department said, no, it's sub judice. This is the objection raised by it. Sorry, you come to the court. I during the cross-examination, asked the other side, look, you have the records to this, you produced to the Karnataka department, can you give that information? He said, no problems. But he didn't. He didn't discharge his burden of proof. Then I filed an IA and Order 16, Rule 11. Under Order 16, Rule 11 at the time, CPC, I filed application to summon that information. He resisted it. What was the reason for him to resist it? So he's making all these false claims and counterclaims, has no sanctity behind it, and therefore it's nothing but fraud. And I do not owe him anything when he doesn't discharge his burden of proof. Further, big APCO bricks, a solid block or hollow block, which is a higher grade. He bought it from a local SLV enterprises, which he has shown on the bill, which I pointed out page number, exhibit number, and it's cheaper. He does all this. Naturally, he only gets what he deserves, not more. Reasonable amounts of money, which the engineer commissioner covers. Now, having regard to all this, if I have not missed out on it, from State Bank of India, and now in his cross-examination, he doesn't know who his employee is, who signed under Puja Construction on a couple of exhibits, which are cash receipts for 13,000 rupees and 20,000 rupees. And he says, I don't know whether she was hired by me. He had that establishment for a long time. So that money he has not accounted for. Then there are two bogus checks for total 45,000, which he has made out in his name. The income tax people wrote to me and said, with a copy to me, saying that it doesn't show that Mr. Balkrishna's, my signatures is on there. It does not show that. It does not show my signature on there, so it's a bogus check. Then as far as defects liability period, I have included the rainfall data for GKBK Post Yalanka, which is adjacent to the site property. The reason I have done that is because it documents not only the rainfall data, but when it happened. During the course of the year, there's a southwest monsoon, northeast monsoon. And the defects liability period is for the period that says 6 months or monsoon, whichever comes later. First of all, he has not finished his work. Secondly, it is later. Whereas in his memorandum of appeal, he says it is sooner. Maybe it is in other contracts. With my contract, it was later. So it extended beyond 6 months. And moreover, because the leakages were happening at that time in the roof, and I made a walkthrough of that exhibit also is provided. Now, maybe time is not of the essence of the contract, but the point is, Hasbury's Law of India and any common law decision will say there should be reasonable, there should not be unreasonable delay. And having regard to Section 73 and unliquidated damages of the Contract Act, it is very clear that consequential, it need not be foreseeable. It's not a foreseeable thing. Maybe he didn't know. He was not aware that I was renting the house. Although my GPA holder subscribes to the fact that he was completely aware that the house was being rented by way of exhibits, I have marked it. I have marked it. Now, comparative quotations, cost of cement, I have included. I suspected him. Even the first two bills, according to the engineer commissioner's report, and the third bill, there are tabulations in error and all. But he certifies it to the nearest paisa. He doesn't keep records. And how do I know he doesn't keep any records of his own? Because the Council of Architecture says so in Exhibit D40 of his submission, page 462 of his submission, part 2. So, no, the only genuine attempts to take measurements in a manner that fits the bill of an expert opinion, because you just don't take physical, like one line after the other, you don't keep pulling the tape. There are what are called scale drawings. There are what are called beams. Each beam, there are approximately 12 cross sections of beams. A beam is something that you see up there, which supports the roof, for example, in this hall. It spans between two columns or two walls, which holds up the beam. The beam is a horizontal structure. Now, each of those beams, they'll have less steel, some will have more steel, depending on the cross section. If I take a typical cross section of the beam, you will find that he has built for 1,200 running foot of beams and lintels. Lintels are what? Yes. No, they also made a comparison of estimates in chartered engineer and registered valuer's report. It is very clear to see that they are fairly close. The chartered engineer and the valuer and the EC's report, both expert opinions, they just show. I'll quickly read on page 25. 23.6 tons of steel for R&A, 22.7 tons, even less for the expert commissioner, whereas the respondent has built 30 tons. What he has done, and according to the EC, he has just increased the quantity of concrete, taken a rule of thumb. Mind you, having 12 different cross sections is different than just taking a rule of thumb. For beams, I'm going to put so many kg per CFT. That's unacceptable, my lords. My lords. Yes, this is the final, Your Lordship. Not at all. But I have made reference to the documents I have produced. Yes. I have specified which ones they are on first page and second page, so that you don't go fishing expedition unnecessarily and waste the time of the other. They're looking in other. Um, yes, okay. Seven, four. Yes. That's all. This up by. illustration on page 25. The RCC beams, as they're called, concrete reinforced rods within the concrete. And whereas the item ground floor concrete, for example, there was no change in the dimensions. Yes, I have. On set, it should be there. 452 CFT, cubic feet, according to the Ranganath and Associates, and 487 CFT, according to the EC, whereas he has built for 1082 CFT. It may not look like much, but when you translate it into a typical length of beam, it'll go around this room one time completely, without including the fact that it has walls also. So it's counted the walls also extra. Yes. Now, grounds. I would like to come to the grounds. And one more thing that the opposite side argues. He says that there is huge increase in quantities of construction. Very clear with you. He's already mentioned it in his proceedings, the written statement in this case, apart from practice rule 3, anything that you submit in the court is a pleading. I'm talking about only the written statement. I'm replying only to that. Now, as far as his contention is that the reason it was difficult for him to do is because he increased the volume a lot. But if you look at the tender, there are unit rates, and there are also estimates for the total quantities. Some of the unit rates are unit rates only. In the first plan, P1 drawing, sanction plan given to the Yelahanka Municipal Township Council, TMC, it shows a big pond, huge pond. You can't deny it. It shows sloping roof. And the setbacks, as I'll repeat that, it's very important. The setbacks is the boundary of the building, for example, extending from outside the walls to the compound wall are exactly it is less in the working drawings, less in the final drawing prepared on computer-aided design drawing, which means the area did not increase on the ground floor. On the first floor, it did increase by 450 square feet on the outhouse and on the terrace gym. That's it, 150 square feet. Now he refers to square feet as on the plan. The architect has understated by 440 square feet the square feet given in the plan to the TMC. That verified simply because of computer-aided design drawing. And that is not an issue actually because the rates, quantities, tender, non-tender came up later, but it's not based on square foot, it's only based on unit rates and quantities. So he cannot claim that, give that name excuse. Another thing, another thing that is mentioned, I'll take the grounds. I'll go straight to the grounds in support of my arguments. On page 25, the bottom, in the citations in respect of whether it's an expert opinion or not. It will take up more time of the court, but I'll be happy to explain. So I'll go straight to citation number 1. Oh, I'm sorry. I didn't think I would be arguing, so I didn't bring my citations. But I've highlighted it where it clearly says that the work of an engineer commissioner, even in a PWD department, is different from somebody who's just goes and measures some boundaries on a land. I mean, this is a PW engineer, assuming he's capable, there's no reason why we shouldn't make that assumption. It's a rebuttable assumption, but he studies, engineer studies a specialized subject called estimation and quantification in theory and practice. I brought that book with you. I too have studied it, but decades ago. I've highlighted it so it's very easy to see the citation, and I will do so after I go through a reply to his defense. Your Lordship, the reason I mention this is simply because a judge cannot poke his nose.
This work must be done under the approved executive as applied this so that
My lords, the reason I make that that observation is simply because no judge. Why should I waste time? You got about 50.
They have examined those experts, no?
Yeah, they were.
They have examined. They have elicited in their evidence what is required.
Yes, I've included all of those observations that are false and inappropriate as far as the trial court said.
No.
Can I go to that?
You PW1.
I am PW1. This is CW1. That is.
Who is PW2? D. Ranganath. He is expert.
Yes, yes.
He is expert.
He is an expert, yes.
His report is marked as.
Excuse me.
He has given any report? PW2
yes, he has given exhibit number P33. P33, I referred to it. He got involved in the middle of the project because he designed a seismic beam. And because I got him involved, because I started suspecting the bona fides of the conduct of the two architect.
Who is PW3?
He's the carpenter who supplied the grills for the windows and the frames. Without the grills being supplied by the contractor, that's the respondent, he could not fix.
Document which was marked through him? Was there any document was marked through him?
No document was marked. No document was marked.
Singh is connected to any documents relied by you?
None at all. None have a signature on there. They do not have a signature on there.
He is not connected to any of those documents.
He is connected in the sense the bills came late. Why did the bills came late for the door frames and window frames? The certificators. I can't do anything until I get the grills. I prepared my wood. I knew it a year in advance. Grills.
He speaks about delay in supply of grills.
Grills, yes. That I mentioned. PW4. Madam, please come to page.
One after another. Examine witness for what purpose?
PW4 is the opposite door neighbor. I have mentioned that. I'll go friend. I asked him to, and he was observing initially. He is not my deputy. He was not paid.
What about his,
not paid.
What about his PW5?
PW5 is the landlord of the holder of the landlord from whom I was renting my property.
DW1 is defendant.
DW1 is defendant.
Who is DW2?
His plumber who worked on my project a little while, and then I filed a police complaint against him, FIR, for not returning tools.
So plumber who was employed by DW1.
He was introduced on the project by the respondent as a plumber.
DW3?
DW3 is none other than the architect. After being disciplined, he became a witness. It is on pages 12 and 13, Your Lordship. All this, whatever I've just said, it's on page 12, 13, and 14. 12 to 14.
Yes.
Exactly what was extracted from them, as far as I can see in support of my arguments, it's there, 12 to 14. Issues are also mentioned. Now, the court fees, KCF and SV have paid us on the basis of 19.13 lakhs, same as in the trial court and before this Honorable High Court. Now, I want to just try to emphasize that if I'm a surgeon, I don't think a judge can say, you have to operate this way, lift your scalpel that way, do the cutting this way. That is exactly what if you will see, that is exactly what the trial court judge did. And even then there were false observations of fact. If I'm a contractor, he calls Ranganath and associates an employee of me. I am not an employer of anybody. He's a consultant, he's a services provider. I can't. I'm sorry. Next, the comparisons that were made, again I repeat, the EC did only the disputed items. How did we arrive only at the disputed items? Because Ranganath and Associate already identified 50 undisputed items. It's not that the contractor did everything falsely. there were 50 items of work which were removed from the assessment for Rangnath and Associates, for EC.
Yes.
A remainder, there were another 100. And not 100, but between 50 and 100. So those were non-tender works. He applied, even though there were tender rates, he took non-tender rates for them. That is totally unjustifiable. He followed one procedure in the first bill, and second procedure, he did another bill. For example, he built some sump tanks. He put the concrete block unit rates for the sump tanks, plastering separately. When he went to the second bill, he took a lump sum per liter basis. You can take a lump sum per liter basis, but you arrive at that only after you have done the unit rate analysis. And after you do the unit rate analysis, you come up with the cost. Then you take the volume and you divide it by the cost, you divide the rupee cost by the volume, you get rate per liter, as an example of a tank. And I have comparative quotations for what he calls a swimming pool. It is not a swimming pool. It was infested with mosquitoes. It was an unfinished concrete tank. The exhibits are shown in 26 photos, color photos are shown, marked, which shows that he just left the site, making money elsewhere. And there was a lot of algae and problems and mosquitoes. So I had to file for inspection of that particular item of work. But it so happened that the respondent said he wanted the court commissioner appointed for the entire work. So I agreed.
How I can answer these grounds, which is not found place in the appeal memo. I will take your lordship the appeal memo.
See, at least in the ground appeal, there may be a clause, such other grounds which may be asked at the time of hearing. If it is their general ground, it's okay. But first, we have basic pleadings and
not related to the grounds. Just I will take your lordship with their appeal memo, my lord. Appeal memo, those legal grounds are raised. These
we
grounds
have several times asked them to be precise.
Yes, my lord. Nothing. How it is related? These grounds, nothing to do with the appeal grounds.
Because trial court issues, they are also not very specific. What was the grounds of this claim?
His entire plaint is based on the architect RN. Entire plaint is put forth based on the ex parte report received from the RN. PW2. Then that on that basis prayer was made. Then court disbelieved that RN's report. Then commissioner was appointed.
PW2.
Yes, RW2, Mallar. PW2, Mallar.
I would like to complete my arguments, Mr. Karnataka Counsel.
Why I am telling, my lords?
Consulting engineer, RN
is Rangnath and Associates, my lord.
Rangnath and Associates. He's a civil consulting engineer.
Yes, D. Rangnath, PW2, my lord.
Learned Counsel.
Mr. Appellant, you have to complete it in a time-bound manner. You first, that's why. You have mentioned in your written arguments that we have directed you to do something. We have not directed you to do anything. We said you go one by one. What is the foundation for your claim? You clarify that. That we asked you to clarify. You have to go in a structural manner. Just going around.
In my updated synopsis.
In a structured manner, you have to go.
If you go through it, because the devil is in the detail, your lordship, this is not something, because if it was such a simple thing, I could have made it into 3-4 pages, but you want the exhibits, you want verification, and the trial court has been abused process.
At the hearing on 2025, court directed that the appellant to prove that he is entitled to these things. We didn't direct you to do something. We said even now also we said, you have to tell us what was the agreement, what was the term, which term was violated, what was the base of your claim. In that way, you have to argue.
Yeah, your lordship. Now, I am also have to address the learned trial court's judgment, and I had put principle.
You are not able to. Assist us are in the manner required like an advocate.
No, updated synopsis, I submitted principle. Now I am substituting with grounds.
Synopsis you have filed. How many times you will file it?
No, what I'm saying is...
Now we have given a pen drive which we had not directed you.
No, that is part of what I was going to submit anyway.
No, you cannot argue years together like this.
Yes. I'm just going point by...
See, you have made certain statements. You should be bound by your boundary, your limitations. What is this submission? False statement. ಅದೆಲ್ಲ ಒಂದು ಕಡೆ ಹೇಳಿದ್ದಾರೆ. The impugned trial court judgment inter alia contains false statements of facts.
That is true.
You can say incorrect or not properly appreciated. How do you say that it contains false statement of facts?
Because they never said that.
You can say the other side statement is incorrect or the court has not properly appreciated that. We are patiently hearing it. But still you are not understanding that we are seeing here. All along you are making allegations against the court, it seems. In page 29 you say, what did you do? Did you take it to any logical end? Then that complaint will have been closed.
Chief Justice says anyway he has been transferred, so there is no need to. This is what the feedback I get.
What is that?
It will be in the court records, judicial notice.
It is not court records. When you file a complaint, you should
Vigilance.
take to the logical conclusion, and when you make allegations here, it should have some basis.
I have done so, Your Lordship. Registrar General.
For that.
I'll produce it.
You cannot say in the thin air that you have complained to the Registrar General, you have complained to the Chief
It is in
Justice.
writing. I'll produce it at the next.
If you had given in writing, then what was the end of the what was the ultimate result in that?
The court has to decide. It's a self-policing situation. More 9 times out of.
You have filed so many right to information applications. You are mentioning. Then did you file any such application here?
Yes. I've given the date also when it was filed.
Complaints might have been closed.
Order 16, Rule 11, I have filed. It is on the court order sheet. Even that is,
here,
I will bring.
Not here.
Not here, in the trial court.
So what did you get?
The court didn't.
What did you get?
The court didn't even. I don't think they numbered it even, and they just ignored it.
You said you filed complaint here in the High Court. You should have taken it here.
No, I was not in the
trial court.
After I came returned to India only after.
Again reminding you, you should argue in a structured manner. Otherwise, we'll refer you back to the party-in-person committee again. We are not getting any assistance from you.
Okay. Your Lordship, I'll do my level best. I'll just go through what I call principles applying the law to the facts. That is my job. Whether it is whether I'm doing a good job of it or not, that's different story. Ground 2 is that he followed the rules.
Written statement will be kindly seen, my lord. I'm excusing for the intelligence. The written statement can't understand what he's wanting to enlighten this honorable court, my lord. Just I will take your lordship to the written submission, my lord. Written submission shall be always.
Mr. Counsel, you will be knowing what was the claim was based on what facts. To pass judgment based on that. If it is accepted, we find something in that, we may proceed to pass appropriate judgment. Either way, this way or that way.
Yes, madam. Yes.
Ground 2 is just to say that he followed the CPC rules, specifically 18, since that is alleged that somehow the other parties were not included. Yet there are a number of documentations where the EC called all the parties, even the R&A called, attempted in person to go to the office of the architect, and the defendant came to him. All of these are marked as exhibits. So there was ample opportunity for cooperation, which was lacking. Deliberately they're avoiding. In fact, the architect says in his deposition that he refused to attend the EC's meeting simply because R&A was there. He refused to attend the meeting because R&A was there. That is in his deposition. I have noted it. On which page, which volume number 1. Number 3, Your Lordship, ground 3. The trial court acted ultra vires. It does not have the competence. When I say competence, that's a technical term in arbitration and in legal parlance, and exceeded its jurisdiction. Both are synonymous. By opining on the ECs and RA's means and methods adopted to carry out the memo of instructions. He has explained very clearly what the memo of instructions he received from both litigants, and he has complied where he can comply, where he could not comply. If you look at the initial report, first few pages, everything is mentioned. I have referred to it here. The trial court has competence to adjudicate, but is restricted to issues of whether the EC complied with the above provisions of the CPC and the memo of instructions submitted to him by the litigants. He gave no specific directions himself as the court. I'm sorry, the court did not give any specific directions itself. Ground number 4. there is this. Now for 4 months, the judge who posted it for orders, final orders on 11/1/2010, for 4 months, he did not say anything about the report. For another 2 years, the judge who came subsequently, he said nothing about the rejecting the. For 2 years, he said nothing about rejecting the EC's report. In fact, since he pressurized, insisted that I come to the court through my lawyer and said, you accept certain amount of money, will you accept certain amount of money in open court in front of both lawyers and the litigants? I said, told the defendant, that is the respondent, come, let's go to the site and let us measure. He said, no. What did the court say? The court said, there is no need to. This is what the court said. I have stated that in my IA and I stand behind that, and my lawyer is my witness. The other lawyer is dead. So this was since no measurements were taken at all. And in fact, when I went to the Council of Architecture with the architect, I told him also, I'll pay you money. You please come with me and we'll measure. He said, no, I'm not coming. I said, I'll pay you. He said, no. Okay, that is between him and I. Now, he is not a necessary party for the reasons I've explained. It may be necessary for relevant evidence, but it does not go against his legal rights. This is a Supreme Court judgment which has been followed, which I have produced on page number 1. I have just mentioned that. Para 2 on page 3, Your Lordship.
Which page 3?
Page 3, written arguments. Para 2, sorry, page 4, top para. The architect is not a necessary party in the suit. In Thomson Press versus Nanak Builders, pages 13 to 14, para 29, which I have attached to the.
Is there an issue that so and so is a necessary party here? That's why we asked.
No, in a different forum he was, because
here he was not there. No.
His claim is not. My claim does not address his legal rights. In no way tramples his legal.
That's why we asked. You are trying to impute everything to us.
No. Your Lordship, back to page 27. I will finish up. Back to page 27, ground number 6. A contract is voidable by the party against whom fraud or misrepresentation caused this consent. I need not repeat this, what free consent is. Under section 19 of the Indian Contract Act, contract is voidable when consent to an agreement is caused by fraud or misrepresentation, provided the aggrieved party had the means of discovering the truth with ordinary diligence. Did I have it? Yes. If I had the information that he had given me, he's not given a bill for 11 months, and it's a huge bill compared to the first one, and it's not in. Then.
Enough. We have heard you enough. Yes, any response from your end?
Your Lordship, IA number 4, I have to.
I have heard you.
Restitution.
Please, there should be stop somewhere. Yes, Mr. Counsel, please tell us.
Yes, my lord. My lord, I will take your lordship to the prayer of the plaintiff in the suit at volume 1, page 19. Relevant page 36.
Please tell us the heads of the account and come to the written statement directly.
No. See, please tell us. What was the ground for the claim?
Yes, my lord. That is he is totally confused. I will take your lordship to the.
That's what. But how did he meet that? At least they should have understood what is that.
My lord, what has happened? The suit was filed after notice claiming 17,48,000 interest at the rate of 18%. No fraud, no nothing. He's telling excess billing was done. Even no substandard was pleaded. Excess billing was done. Suit is entirely based on report of the exhibit P33 of R&N Associate Matter. Now, trial court has specific.
First ground is that excess payment, excess
Yes,
amount was charged in the bills.
Yes, my lord. and he made an excess payment. And first of all, here there is no contract between the parties.
Yes, inflated bills.
Yeah,
Inflated bills.
inflated. Yes, madam. And there is admittedly there is no contract, written contract for construction, madam. There is no construction agreement. Some rates are quoted; those rates are accepted.
That is one excess payment. What is the other? Any other ground?
Madam, there is a plaint is very vague. Does not say anything. How the argument is canvassed, like that only pleading was done, then amount was claimed.
And the rental work is better.
The patient 20 para 20. 22 ಆಯ್ತಲ್ಲ 22 delay in execution of the work. Second one is delay in execution of the work, but that rental
That's also
rights,
not there, madam. That's also not there.
that is also not there in the petition
Plaint.
claim.
Yes, madam. Yes, madam.
ಇಲ್ಲ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು.
ಇಲ್ಲ.
ಏನೋ ಹೇಳಿದಾರಲ್ಲ.
ಅದ್ರ ಬಗ್ಗೆ ಕ್ವಾಂಟಿಫೈ ಏನಿಲ್ಲ. ಈ ಎಂಟೈರ್ ಪ್ಲೇಂಟ್ ರೀಡ್ ಮಾಡಿದಾಗ ಕ್ವಾಂಟಿಫಿಕೇಶನ್ ಏನೂ ಇಲ್ಲ.
Delay in execution. Delay in execution of work. ಅದಕ್ಕೆ leading to rental. 32. Plenty filing to rented building ಅಂತ ಅದು ಇದೆರಡೇನಾ? ಎಸ್, ಇನ್ನೊಂದೇನೋ ರಿಪ್ಲೇಸ್ ಮಾಡಿದ್ದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ ನೋಡಿ ಡಿಫೆಕ್ಟ್. ಎಸ್ ಎಸ್
Yes, madam. Now, the written statement was filed by the defendant, denied all the claim, put forth the counterclaim. Counterclaim at find page 52, my lords. Page 52 of volume 1.
Yes.
Tabular in the right hand side, my lord. Balance payment against the 1, 2, and 3 final bills 1,05,283. Security deposit is the admitted amount 1,23,000 as per that contract. Security deposit has of correction demolitions apart from the construction. This was the claim, entire counterclaim around 4 lakh 3 bills. 3 bills.
Yeah, have you filed any appeal?
Yes, my lord. Connected appeal for counterclaim in 1922 is my connected appeal, my lord. Your lordship may find issues at page 72. The defendant is related to the plaintiff. Plaintiff is an engineer himself. On all the time, he or his architect were on the spot, looking after the progress of the work. And on each occasion, the bills were certified, payment was made after measurement. Minutes. I have stated, your lordship. Yes, my lord. My lords, I will straight away take your lordship to the judgment itself, my lord. As I stated, The suit is based on the report of the R&N. That was an expert.
R&A.
Yes, ma'am. That's Ranganath and Associates, madam. R&N short form, madam.
R&A. No, contract valuation, R&A, running account. Yes.
Madam,
Where are you?
yes, I will straight away take a lordship page 104 of the paper book number 1. Yes, madam. These are the issues may be kindly seen, my lord. Whether the plaintiff proves that defendants are liable to pay sum up to be 17,48,000 with interest at 18% per annum. Whether plaintiff proves that there is a cause of action as alleged. Whether the defendant proves that plaintiff is liable to pay 4,88,255 as a counterclaim. Whether the plaintiff is entitled for the decrease sought for. And whether the defendant is entitled for counterclaim. Major issues, issue number 1 and 3, my lord.
Actually, they should have framed the issues like this with reference to these other plaintiffs prove that there was excess billing leading to his excess payment. He only random rate. Yes.
Yes, madam. All the issues are answered in the negative. Suit and counterclaim was dismissed. Against which these 2 appeals are filed before this honorable court, my lord. Now, what was the suit has been properly recorded with the trial court at page, internal page 33, running page 105. Entire suit, plaintiff has brought the suit for recovery of the excess payment, para 10.
Yes.
Page internal page 33, para 10.
Yes.
This fraud, these all the misrepresentation, fraud, nothing. There is no pleading. So this is for recovery of the excess payment based on the report submitted by the PW2.
Yes.
This was rejected by the trial court, stating that the report at exhibit P33 given by PW2 is a one-sided report and no opportunity was given to the last 3 lines. The suit claim is mainly based on the report allegedly obtained from the independent valuer, namely Ranganath and Associates. Entire suit is based on that report. Exhibit P33. That report was outright rejected by the trial court. Your Lordship will see finding at page 43. First 5 lines, my lord.
Yes.
Page 43, first 5 lines. Plaintiff from Ranganath and Associates who are appointed unilaterally by the plaintiff, and also the defendant was not a party to their inspection and measurement. Therefore, exhibit P33 gone, based on which plaint was drafted. When this was rejected, my lords, there was a benefit for the trial court to look into the evidence of CW1, who called to be independent examiner, a architect, an engineer appointed by the court, who was examined by CW1. Now I will take your lordship to page 44. He marked 3 documents. CW2 is the report, my lord. Before report, I will see how that evidence of CW1 in the absence of the evidence of R&N at exhibit P32, 33 treated by the trial court, my lord. First, my lord, there's an extract may be kindly seen, my lord. But at page 44, extract. But CW1 Srinivasa Murthy, who is a CW1, has admitted in his cross-examination thus, when I checked the measurement, the defendant was not there. Page number 2. I have not given any notice after first meeting to anybody. I used to fix the meeting and inform the parties over phone. Notes regarding the discussions made by the parties in the meeting. So that notebook is also not produced. Notice not given. Next, I will take your lordship to the very same page, bottom, para 18. I have not produced other than exhibit C1 to C3 before the court. It is true that I have not recorded the measurement on any of the papers. I have not produced details given by the plaintiff to the court. I have not prepared list of disputed items. This is the evidence during the cross-examination of CW1. Next, my lord. Finding recorded in next page, para 19. The above from the paper nor prepared any list of disputed items during his work. Hence, the question arises as to how could a court commissioner recollect, refresh his memory while preparing his final report without reference to any notes. Another question is how far the report of such witness will be accurate and dependable. This is the finding recorded, my lord. Now I will skip there, my lord. Next page I will go, my lord. 47, page 47. Again, the evidence of CW1 has been extracted. It's an admission. Page 47. Bottom, my lord. I have not measured the thickness of the plinth concrete physically. I have not measured the entire building constructed. This is it goes to the root of the report, my lord. That is constructed area. He has not measured. I cannot say the total constructed area is 7,400 square feet. I have not mentioned the measurement, thickness of the plinth concrete used in the building. I cannot say the thickness of the plinth concrete, where is 9 inches wall, it is 5.5 inches. I cannot say the plinth concrete of the compound wall, thickness, ties, and etc. As can be seen from CW1 asserts that he asserts that he had made the measurement and prepared the report basis of the drawings supplied to him by both the parties. But admittedly, no such drawings are enclosed to Exhibit C1 to C3. As such, it is very much obvious that such drawings which are very material are suppressed from the court. As such, admittedly, Commissioner report SMC has no basis at all. Now, my lord, next I will take the next page, my lord. After 3 lines, my lord, page 50. As such, his evidence is very much vague and ambiguous with regard to the thickness, size of the important components. Had really the commissioner visited and measured the physically, certainly he would have been able to give whatever details are sought in his cross-examination. His failure to come out with the specific measurement of above said aspect would only go to show that he has not properly verified and measured the disputed items. Hence, how can it said that he has actually quantified the work executed by the defendant? Even it is very interesting to note that CW1 has also admits thus, very important matter. Neither of the parties have given a list stating that these disputed items are drawings. I have not prepared a list of disputed items. Next matter, para 22. The above admissions goes to show that court commissioner did not have any list of disputed items before him while executing the commissioner work. The CW1 has further admitted in the cross-examination thus. It is true that I have not given calculation sheet regarding plastering work in Exhibit C1. Item number 31A is prepared by my student. As per my instructions, the name of the student is Raghuveer Rao. That measurement report of Raghuveer Rao and Raghuveer Rao is not examined. Next para is very important, madam. The above admission but his evidence before the court shows that the said measurements were actually not taken by him as stated in his report, and on the other hand, it was taken by his student Raghuveer Rao. As such, his own admission falsifies his report before the court. So, these are all findings regarding CW1 as Exhibit C1 to C3 falsifies the case of the commissioner and the plaintiff. When first report was a unilateral report was rejected, when second report not admitted, there is no basis for the suit to stand on its own leg, because this suit is based on the R&N report, that was unilateral report, finding was recorded, and the court commissioner report is without measurement. Then suit is bound to fail. Rightly done by the trial court, my lord. Next, my lord, page 128, page 56, internal page 56, para 28. Nextly, it is most important, it is most pertinent to note that CW1, Dr. Srinivas Murthy himself has admitted in the cross-examination thus. Question: contractor has to execute the work as per the design and instruction given by the architect at structural engineering. Yes. It is true that architect has approved all running bills. This is very important, my lord. I have seen the running bills before the court numbering 1 to 21. It is true that at the time of executing a non-tendering item, rates analysis are prepared and allowed. Witness volunteers that it has to be prepared by the contractor, approved by the architect, and accepted by the owner. In respect of the non-tendering items submitted by the defendant were on the basis of the rate analysis only, and also they were duly accepted and approved by both the architect and the plaintiff. Such being the case, it's very strange to note that Commissioner himself has not allowed the rate analysis in his abstract. Hence, I hold that there is no basis for reasons for conclusion arrived by the Commissioner in his abstract. Under all the above circumstances, I come to conclusion that there are several serious and material discrepancies in the report submitted by the Commissioner. It is also very much obvious that there is no basis for or foundation either for differences in the quantity or the amount or for the reasons remarks stated by the Commissioner in his abstract produced under Exhibit P3. Therefore, in my opinion, the court commissioner evidence or the report submitted therein cannot be accepted and acted upon. Therefore, finding is properly recorded by the trial court. Now, I will take a lordship to the first R&N report and his cross-examination, page 62. Ink page 134. Evidence of PW2 is extracted in para number 35. Your lordship may see, my lord. In addition to the above, PW2 has also clearly admitted thus. Your lordship got, my lord? Yes. The documents which I have seen are Exhibit P3, 5, 6, 7, 8, 13, 14, 15 to 20, tendering my report. In addition to that, I have seen Exhibit P49. When I visited the spot, I had an idea to interact with the architect and contractor. I have not issued any letter to architect or contractor. Because to show that this is a unilateral report. This is the admission of PW2. Now, my lord. Regarding, he was telling the rent was given. Refuted it. Page 66. Page 66, bottom, my lord. Evidence of that witness extracted, my lord, cross-examination. It is true to suggest that we have not given house on rent to Jayant.
Who is that Chetan Kumar?
Who was examined by the plaintiff to show that he was in a rented house for belated period.
Anish landlord, but he says this was rented to one Chetan Kumar.
Yes, my lord. He, not to the plaintiff. Specifically says not to the plaintiff.
That is an IA 2 of 22.
Next, my lord. Page 40. This is admission of PW. Page 67, para 40. Next page. In addition to the above, it is also most important to note that PW1 Jayant, the plaintiff himself, has clearly admitted in his cross-examination thus. It is true that the defendant has executed construction of certain items which were not covered under the tender. Is the excess item, my lord. It is true that defendant has executed non-tender work which is as follows: one swimming pool, some, etc., my lord. These are the extra items not covered under that tender, my lord. Next, last two lines, my lord. Defendant has to execute the work as per the directions of the architect. Architect is DW2, DW3 was appointed by the plaintiff. Was raised, bills were approved, payment was made. Only under these 3 bills, 1 lakh was due, my lord, apart from retention amount. If really in the third bill, your lordship may see that 3 bills. First bill around 4,88,000. Second bill is around 24 lakhs. Third bill is 14 lakhs, my lord. When submitted, entire payment was made. After third bill also, on 6 locations payment was made out of 14 lakhs. If really that excess work was there, he would have been withheld that work, without the payment. Only 1 lakh was due in the third bill also. Total in the 3 bill, 1,04,000 was due. That is the first item of the counterclaim, my lord. Therefore, my lord, finding may be seen at page 70, para 43, my lord. Finding on issue, my lord. Issue number 1. For the aforesaid reasons, I come to the conclusion that the evidence and materials placed by the plaintiff before me is not convincing and acceptable to establish any excess payment made by the plaintiff to the defendant. Therefore, I hereby come to the conclusion that there are no sufficient evidence and material to hold that plaintiff is entitled for any reimbursement from the defendant. I hold that plaintiff has failed to prove the issues. Accordingly, I answer the same issue negative. Rest of the issues is of no much importance in this case, my lord. Regarding my counterclaim, I have demonstrated that as per the 3 bills, 1 lakh was due. Retention my amount, 3% retention was done. That is also admitted fact. 22,000 extra item was done by me. Another 2 lakh extra item, 4 lakh counterclaim I have as per the terms of contract, my lord. That was claimed by me. He is my relative. Therefore, the trial court has erred in dismissing my counterclaim of 4,88,086. For that, document itself shows that I am entitled for that with the proper reasoning. Therefore, appeal, first appeal 1473 may be dismissed. My appeal 1922 to be decreed. I may be granted counterclaim of 4 lakh rupees odd, my lords. That's my prayer, my lord.
Same receipt board label. Right. Counterclaim. Is also rejected. 76. Reply. You have to be very precise. Yes.
Just one small addition, my lord. He making against his own architect, against the contractor, against the judges. That's why I left out, my lord. In pleading, a ground was taken against a judge, my your lordship are rightly told. Against a judge, a personal allegation has been made. And in the affidavit, it's a most of a perjury, my lord. It's a contempt. And he's an educated person making that kind of allegation on oath against a judge who is retired now. That may be, that ground may be kindly seen, my lord, that ground. Page 40, appeal memo, page, volume 1, page 16, para 42. That kind of allegation shall be deprecated.
Page 62.
Page 16, volume 1, para 42.
This is not volume 1. This is volume 1.
Pink color, my lord, volume 1, page 16, para 42.
In volume 1, there is no para 50.
Page 16, para 42.
Yes.
Bottom, my lords.
ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ ಕರೆಕ್ಟ್ ಪೇಜ್ 16 ಅಂತ ಆದ್ರೆ 60 ಅಲ್ಲ 16
page 16 para 42, my lords.
Yes.
What, my lords? Yes, my lord. A fax and a letter was sent by the helpless appellant who lives overseas to the administrative judge of the High Court and to the Chief Justice of the High Court of Karnataka, complaining of the infuriated attitude of the trial court judge after the Karnataka High Court passed a direction to the trial court to dispose of the case. A second time, since there were inexplicable delays in hearing the case, the apparently infuriated judge declared in the open court that he would pass adverse judgment against the appellant for having sought direction from the High Court. The helpless appellant had little time to apply for a transfer petition. The judgment was passed the first day after reopening of the May court session. May court session. Next, my lord. This is the way, and again in the application also similar, in the written argument is similar. Repeated objection with the name. That shall be deprecated, my lords. If he is a rustic villager, it's considerable. But he is educated according to him, he is an advocate. Party in person, making this kind of allegation.
Absolutely no cooperation from the architect and the defendant for taking measurements assessment at the site. As far as Rangnath is concerned, please refer to volume 3. All of these refer to volume 3, exhibit P34A. That is a letter sent by me with a copy to volume 3, appellant's paper book, volume 3. Page P34A, page 632.
Yes.
The letter is self-explanatory. It says that a time was given at 3 p.m. The architect did not show up at his office, and that there was exorbitant discrepancies. We needed clarification of that. After giving appointment, he did not show up at his office, the architect. Then again, page 630, RPD letter was sent to the architect. Then on P34B, next page, 634, letter was sent by myself with copy to R&A saying that defendant should get off the job because there's huge discrepancies and he did not have the time, even though he approached Rangnath and Associate Office. He did not have the time to spend with him to clarify the construction work is given. R&A, and this is corroborated in the deposition evidence affidavit of R&A as PW2 says he came to my office but refused to cooperate to explain the doubts that R&A had. So contact was made. Next, architect Rangnath and Associates.
Who engaged?
I did.
You engaged?
Yes.
Whether the defendant consented for it?
No. But he was, after he assessed it, there were doubts and he wanted to make sure that there was something to discuss with the contractor. Then only we contacted, but they refused to make themselves available. He refused. Then on page 9, on page 9, very critical, para 13.
How is it finding binding on the defendant?
Binding on the defendant simply because there was no measurement taken up until this time. He is a necessary party to show that those measurements were actually taken and that they are valid. So you have to have an umpire, and that umpire I consulted. He's an independent consulting engineer. Who else can I go to? Either I have to go to the horse or I have to go to the rider. or something like that. In this case, the horse was the defendant. He has not shown any valid valid measurement. Simply, first of all, there were no, he billed to the nearest paisa, but he was off the mark by 30,000 rupees. All three bills, there were tabulation errors if he went to the nearest paisa. Then why couldn't he have come? Why didn't, what the onus of proof is on him also? Why didn't he volunteer? Is there any documentation to say that, look, hey, come, I did it right. Come, I'll prove, disprove you. He didn't come. He's avoiding all the time. And please look at page number 9, your lords, my lords, page 436. This is a letter by me with a CC to EC, that is Dr. Srinivas Murthy and to Rangnath, because I was directed. I state specifically that I am directed by them. I don't have that volume in front of me right now, but I know what it contains. It says that I'm writing on behalf of, I'm an agent. I have actual authority, which is not refuted by anybody, to make that communication to all these people to come to the next meeting, next site meeting. So they were informed. In the deposition of architect PW3, he states that I did not come to the meeting. I received that document. I didn't come because Rangnath and associate was there. What is the reason for these people to hide? Why didn't they come forward themselves if they were genuine? I asked that question. I asked myself that question. Then, in respect of the letter marked as 24, which I authored, then there is another letter, also P25, 441. Please see that, your lords, my lords, 441. I think that was the letter to the architect, asking him, his consulting engineer, the structural engineer is hired by the architect, or he will have his own structural engineer for the house. So both of them were asked to come. Neither of them showed up. They could have written a letter saying that, but they acknowledged receiving this letter. Page 441, P25. Then, further down on page P41, your lord, defendant also got a list in 24A, you will see. I'm sorry, I don't have that volume in front of me. You will see that disputed items, which my learned opposite counsel refers to, disputed items have been sent to him in RPID. He says there were no disputed items. What is the big deal about that? Why would I dispute non-disputed items? So that list was sent to him, 8 pages. It's mentioned there. And he acknowledges also having received it in Exhibit D1 of his part. Now, one more thing. Please turn to page 694 of that. One more communication by the Engineer Commissioner. It was addressed to Registrar, City Civil Court, and to the 2 litigants. 2 months before he submitted his reports, he says, please provide inputs. P41 694. In one of those paragraphs, he clearly states, if you have any further inputs to do, you please communicate it before I submit my reports. So either he did not communicate or he communicated whatever he had to communicate. But there were no objections raised, as far as I know. Now, if you look at the Engineer Commissioner's deposition, he said, I made every effort. If I can just have...
Bhagat, no objection was filed to the Commissioner's report?
Filed, my lords.
No, after
Commissioner
the report was
objection
filed.
filed, we have cross-examined him. It's in the volume 3, my lords.
Report after commission work only.
No, ultimately I'm just saying natural justice has been used very liberally by the honorable without anybody's knowledge. That is what I'm trying to say. And I have replied to that also, saying that the objections are false statements of facts. By the way, my lords, I am sorry if I'm upsetting you, but I learnt in Cardiff Law School that false statement of facts is the precise way to define errors. Object. Yes, I am.
Follow the.
But it is still English common law. I won both my.
You have to go by the law which is here, in the prevalence here.
Then he was perverse in his comments. Judge was perverse. In the High Court, they say the judge made perverse comments. Perverse, if you look at the synonyms and the meanings, it can amount to contempt also. Then on page 11, you are addressing his concerns. Page 11 of the written arguments. 17, para 17. The EC's The EC's report states the means and methods used by the EC to arrive at his reports. He states the commissioner studied the details of the memo of instructions, tender documents, working drawings, bills, and field book. The commissioner also had detailed discussions with the plaintiff, defendant, and their respective advocates over several meetings. He is unable to offer any comments to the following issues for the reasons cited therein. So when he says, if you are going to look back for defective work, I wasn't there, so I'm not going to comment on it. I'm going to comment on everything that is within my purview. Then I am just requesting, if at all possible, on page 19, about the subject. He himself is spot on there. Next, in para 16, from the above, it is very clear that admittedly no notice in writing was ever given to the defendant before executing commission work. How is that possible? Just because I write the letter on behalf of the commissioner with a copy to all of them, and they come for the meetings, now suddenly, without appreciating the evidence, considering the trial court judge came in without any personal eye account witness of the witnesses, all he saw was what it was on paper at a minimum. So admitted that no notice in writing was given to defendant before executing commissioner's work. Would you take this for face value, or would you look at the exhibits which demonstrate that notices were given? One to architect, structural engineer, one to defendant for the same meeting, and his representatives to come to the same meeting, and admission in the deposition that architect and defendant was busy. And further, please, Your Lordship, I need another few minutes because I don't have the deposition page number here to read out what the court commissioner said. I made an attempt to speak to defendant, but he did not cooperate. It is there, but I didn't think I was arguing, so I didn't bring that volume.
All volumes with you?
No, it's not mine. I just thought today I have to give the written arguments and go.
Right, that's all. We had asked you only to file written arguments.
You started arguing the matter. We allowed you to argue. We had told you very clearly, submit the written argument or oral argument.
So whatever he's saying, I have addressed here already.
Yes,
And Your Lordship, my Lord, I just want to mention Order 41, Rule 24. This can be determined.
CD is the letter. ಅಲ್ಲಿ ಅದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು ರಿಜಿಸ್ಟ್ರಿ as placed ಅಂತ ಹೇಳಿಲ್ವಾ ಮಿಸ್ಟೇಕ್ ಆಯ್ತು.
My Lord, can I have 10 seconds? Just 10 seconds.
Written synopsis ಅಂತ as directed to submit. ಇಲ್ಲಿ ಇವತ್ತು ಹಾಕಿರೋದು ಇದು ರಿಜಿಸ್ಟ್ರಿ has placed written synopsis of submitted by the appellant along with one pen drive. On 4/4/2025, the appellant was not directed to submit any pen drive. Therefore, the pen drive is returned to the appellant. Heard both sides. Reserve.
My lords, just 5 seconds.
No, we have
Where-
given you more, giving
where-
more than anybody.
Wherever I have stated false statement of
You have filed
facts,
your written
I
arguments.
have
We'll
said
look
per
into-
contra.
we'll look
Per
into that.
contra on the facts. I have referred to exhibits. He said something, the judge, court said something, per contra. Please look at.
Both the parties have filed synopsis. I am filing my rejoinder today. Both the parties have filed synopsis.
It should not be a successive repetition,
No, I am filing the rejoinder today.
not
My,
previous case.
yeah. In fact, I deeply appreciate the patience and perseverance with which the matter is being taken.
You have filed your written submission.
Yes, I have filed my synopsis and I am filing my rejoinder today. I'll be giving it to the learned court.
But you have filed your written submissions and you want to file written.
We have filed written synopsis as per the orders of this honorable court.
Again, written arguments.
No, not argument, synopsis. You really should have directed us to file within 3 days.
They have filed it or not? They have served the copy. No. ಇಲ್ಲ ಇವೆರಡರಲ್ಲೂ ಕಾಮನ್ ಆಗಿ ಅಂದ್ರೆ we asked you to find the synopsis because it would be easy to refer to the exhibits or depositions. Other way, if you have not list, when you are referring to, when putting forth a proposition, if you rely on any evidence or any document, you should mention it there and page number or exhibit number wherever it is. Connected matter. Why you have filed it only in one matter? 8418 of 2024. The other one is cross objection. It serves both the cases. ಇದ್ಯಾರು ಹಾಕಿರೋದು ನಿಮ್ದೆ ಅಂತ ಹೇಳ್ತಾರೆ ರಜಿತಾ ಇವ್ರದಿದೆ ಇಟ್ ಕವರ್ಸ್ ಎಲ್ಲಾದ್ರೂ ಇಟ್ಸ್ ಕವರಿಂಗ್ ಆಲ್ ದ ಕೇಸಸ್ ದೆನ್ ರೈಟ್ ಇಟ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಲ್ಲಿ ಇಲ್ಲಿ ಕೊಡ್ತಾ ಇದ್ದಾರಾ ಎಲ್ಲಿದೆ ನೋ ಸರಿ ಸಬ್ಮಿಷನ್ ಗಿವನ್ ಅಲ್ಲ ಇಲ್ಲಿ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಇಸ್ಕೊಳ್ಳಿ ಅದನ್ನ ಯು ಪಾಸ್ಟ್ ಇಟ್ ಯು ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಇಟ್ ಇನ್ ಕೌಂಟರ್. We will not permit all this business. Once the synopsis, another time rejoinder. How many compilations we have to read? ಅಲ್ಲ ಅವ್ರು ಯಾರು ಕೊಟ್ರೆ ಏನ್ ಹೇಳಿದ್ರಿ ಅವರಿಬ್ರು ಎಕ್ಸ್ಚೇಂಜ್ ಮಾಡ್ಕೋಬೇಕು ಅದನ್ನ ಅವ್ರಿಗೆ ಏನಾರ ರಿಪ್ಲೈ ಹೇಳೋದಿದ್ರೆ ಬೈ ವೇ ಆಫ್ ರಿಜಾಯಿನರ್ ದೇ ಹ್ಯಾವ್ ಟು ಫೈಲ್ ಇವರ್ now we are filing rejoinder to her written synopsis. ಅವ್ರು ಕೊಟ್ಟಿದ್ದು ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ನಿನ್ನೆ ಫೈಲ್ ಮಾಡಿದ್ರು. No. Both of you, see the order is both of you should file the synopsis and serving the copies to the other side in advance ಮಾಡಬೇಕು ಅಂತ. And if correct, now you were asked to file your rejoinder if any for such written statement submission beforehand today he says he is filing only rejoinder. Adikeli, but where is the question of you filing again reply to that? You have filed both of you have no rejoinder again. Here after he filing the written submission you have filed, no? So that covers.
I have filed my written submission first, then only he send me a copy of it.
Anyway, now we are at 449. Otherwise, yeah, gone through his written submission. No, you have got to say anything on that.
I have a few sentences.
No, anyway, it seems the last time she had not completed her arguments. Heard both sides further and ಆಗಿದೆ. Yes. So both arguments. If you want to file, now you are filing only rejoinder.
They have filed one list of
List of documents. ಕೊಡಿ ಅದೇನಾದ್ರು ಕೊಡ್ತಿದ್ದಾರೆ rejoined. Why are you doing all these things? You are asked only to file. Show us your rejoinder. We'll see. It is filed in rejoinder or with the synopsis? Yes, submitted his synopsis in the registry. He both the synopsis of both of them is not put up. When did you file? 4th and 5th.
But she was served on Saturday.
ನಮಗ್ ಇನ್ನೂ put up ಆಗಿಲ್ಲ. It should reach us. You should file it in advance. Registry shall verify and list all. ಅದನ್ನ ಇದನ್ನೊಂದು ಬರ್ಕೋಬೇಕಲ್ಲ ಅದಕ್ಕಿಂತ counsel for the appellant submits his rejoinder to the synopsis submitted by the legal counsel for the respondent. He further submits that has filed ಅಂತ ಹೇಳಿದ್ರು ಬರ್ಕೊಂಡು ಮುಂದೆ list on date 21st. If there is any other document in that, we'll reject that. Or she shows that. Why do you bring other things here? You were just asked to submit your synopsis, not documents. What do you know? What are these documents? Email it. Correct. This amounts to additional evidence. It is not just. Then why are you not? Why are you producing? If it was before the trial. ಇದು ಅಲ್ಲ ಅವ್ರು ಕೊಟ್ಟಿದ್ದ ಕಾಪಿ ನಮಗೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಅದೇ ಅಂತ ಹೇಳಿ ಇದನ್ನ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ರು ಯಾರು ಅಲ್ಲ ಈಗ ಕೊಟ್ಟರು ರಿಜೈಂಡರ್ ಈಗ ಕೊಟ್ಟರು ಬಂತ ಅಲ್ಲ ಅವ್ರ ಆಫೀಸ್ ಕಾಪಿನ ಇದು ಇಲ್ಲ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ ಬೇರೆ ಇದೆ ಅಂತ ಅವ್ರು ಕೊಡ್ತಾ ಇದಾರಲ್ಲ ಇಲ್ಲಿ 24 it was on 24/3/2025 ಅವ್ರು ಕೊಡ್ತಾ ಇದಾರಲ್ಲ ಇಲ್ಲಿ 24 it was on 24/3/2025 not to the present one.
This was to be filed earlier on during the proceedings of the transcript which were there in earlier proceedings.
This was given to me today.
This you have it in the current proceeding also. All these things are part.
See, that is not the part of our record. No. Then you will return it to him. It is not the part of record. You are sure, no? Here, Mr. Counsel. Is it part of our record here?
Under the transport record, yes.
Under that, no. You have submitted it before us. But ಅವ್ರಿಗೆ ಯಾಕೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರಿ?
We wanted to file it as a members in the council it is not required because it only comes for a plan.
This shall verify and ಒಂದ್ ವೇಳೆ ಬಂದು ತರಿಸ್ಕೊಟ್ಬಿಡಿ ನಾವು ಒಂಚೂರು ಓದ್ಕೊಂಡು ಬಂದು ಸರಿಸಿ ರೆಕಾರ್ಡ್
Can I make a suggestion to raise it so? Not to post it after 2 weeks or directions. If the leadership and the government court has any issues to ask.
That's why we said get it. We'll read it. This 21st. No. After 2 weeks we'll not do that. Otherwise there will be no end at all. Yeah, directed to list it on 21st. So we have asked her to get your arguments, if any, in written synopsis. We can go through them on 19, 20 if we get time. 18, 19. Everything is over now. Arguments are over. Written synopsis are filed. But then we are going through that. If we have any doubt, we'll ask you. Otherwise, we'll dictate on that day. Pardon?
I would like to assess if there is any doubt. 22nd.
Not necessary. If that is the case, we'll adjourn it then. Yes. Next question.
Finally,
ಅದು ಬಂತ that has not come. ಬಂದಿತ್ತಲ್ವಾ that had come.
If she is finding any document.
ಇದ್ರ ಲಾಸ್ಟ್ ಟೈಮ್ ಪ್ರೀವಿಯಸ್ ಅದೊಂದು ಪಾರ್ಟೀಸ್ ಅಪಿಯರ್ ಆಗಿದ್ದು ರೆಕಾರ್ಡ್ ಆಗೇ ಇಲ್ಲ ಅಂತ ವಿಡಿನ್ ನೋಟಿಸ್ ಇಲ್ಲ ಅದಕ್ಕಿಂತ ನೋ ಲಾಸ್ಟ್ ಟೈಮ್ ದೇ ಹ್ಯಾಡ್ ಅಪಿಯರ್ಡ್ ನೋ ಲಾಸ್ಟ್ ಟೈಮ್ ನೋ ದೇ ಹ್ಯಾಡ್ ಅಪಿಯರ್ಡ್ ಅದು ಅವತ್ತು ರೆಕಾರ್ಡ್ ಆಗಿಲ್ವಂತದೆ ಸಮ ಇಲ್ಲ ಹೇಗಿಲ್ಲ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾನ್ಸ್ ಅವತ್ತು ನಾವು ಕರೆದಿದ್ವಲ್ಲ ಏನು ರೆಕಾರ್ಡ್ Last time they had come before us. Hello, records claimation. The child shall be kept present on 27/3 ಅಂತ ಆಗಿತ್ತು 27/3 ಅಲ್ಲೇ ಆಗಿತ್ತದು but that is not it has escaped that is not recorded. I mean probably ಅಲ್ಲಾದ್ಮೇಲೆ ಇಲ್ಲಿ ಬಂದು ಏನು ಮಾಡೋದು ಅಲ್ಲಿ ಬರ್ಕೊಂಡಿದ್ರೆ ಸಬ್ಮಿಟ್ ಅಂತ ಆದ್ಮೇಲೆ ಬಿಗಿನಿಂಗ್ ನಲ್ಲಿ ತಗೊಳ್ಳಿ ಪೇ at the beginning ನಲ್ಲಿ on sorry, as per the direction in the order dated 24/3/2025 both parties and child were present before the court and the court interacted with them. However, by accidental omission, the same was not noted in the order dated 27/3/2025. Both counsel accept this position. Drag on the matters like this. Next person. ಆಗೋದಿಲ್ಲ ಇವೆಲ್ಲ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇದು ಆಗೋದಿಲ್ಲ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks ಡ್ಯೂ ಟು ಪಾಸಿಟಿವ್ ಆಫ್ ಟೈಮ್ ಡೇಟ್ ಕೊಡಿ ಇಲ್ಲಾಂದ್ರೆ ಅವ್ರಿಗೆ ಅದೇನೋ ಕೋರ್ಟಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಲಿಸ್ಟ್ ಡ್ಯೂ ಟು ಪಾಸಿಟಿವ್ ಆಫ್ ಟೈಮ್ ಅರ್ಜೆಂಟ್ ಟು 6/6 ಸೇಮ್ ಅರ್ಜೆಂಟ್ ಟು ಡೇಟ್ ಹೇಳಿದೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಸೇಮ್ ಡ್ಯೂ ಟು ಪಾಸಿಟಿವ್ ಆಫ್ ಟೈಮ್ ಅರ್ಜೆಂಟ್ You file it in the registry. Same adrelli. So, due to first day of time, adjourn by 2 weeks. Acceptance of paper publication. R3 56.3 ನಂದು ಇನ್ನೊಂದ್ರಲ್ಲೇನೋ 998 days ಡಿಲೇ ಇದೆ ಅಲ್ಲ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾದ್ರಲ್ಲಿ you appear for them. There is one more appeal other than this. 3835. It is already listed. It is already listed. ಇದರಲ್ಲಿ ಇಲ್ವಾ issued by paper publication is taken on record. Respondent number 3 and Manjunath. Service on respondent number 3 is held sufficient. Karsi Manjunath. Respondent number 3 called out absent. Okay. ಇದರಲ್ಲಾಗಲೇ ಅಡ್ಮಿಟ್ ಆಗೋಗಿದೆ ಅಲ್ವಾ ಏನದು ಅದು ಅದರ್ ಐ ಎಸ್ ಟು ಬಿ ಹರ್ಡ್ ಅಲಾಂಗ್ ವಿತ್ ದ ಮೇನ್ ಮ್ಯಾಟರ್ ಇನ್ನೊಂದು ಕೊಡಿ 56.3 ನಲ್ಲಿ ಅಲ್ಲೊಂದು ಕೊಡಿ ಮೊದಲು ಅವ್ರು ನೋಟಿಸ್ ತಗೊಳಕ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಬೇಕು ವಾಟ್ ಅಬೌಟ್ ಓನರ್ ಇನ್ ದಟ್ ಕೇಸ್ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ ಅವ್ರಿಗೆ ಯಾರು ಯಾವ ಕೇಸಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿಲ್ವಾ ಹಿ ಇಸ್ ಫಾರ್ ದ ಕ್ಲೇಮೆಂಟ್ಸ್ ಅಲ್ವಾ ಯಾರು ಅವರು ಜಗದೀಶ್ ಅಂಡ್ ಅದರ್ಸ್ ಅಂತ ಇದೆ 3835 HJ ಆನಂದ್ ನಿಮ್ದು ಅವ್ರದ್ದು ಕೇಳ್ತಾ ಇದೀವಿ ಅವ್ರಿಗೆ ಯಾರ ಆಗಿದ್ದಾರೆ ಅಂತ ಇದರಲ್ಲಿ ಶ್ರೀ ಏನಿದೆ ಹೆಸರು SJ Anand Learned Council undertakes to appear for respondents 1 to 3. 1 to 3. Shall find the wakalat in the registry within 2 weeks. Adela his name, etc. Issue notice to respond number 4. List on 23/6. Oh, ಅದರಲ್ಲಿ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಅದರಲ್ಲಿ. ಇಲ್ಲ ನಿಮ್ಮ ಪ್ರೇಯರ್ ಏನು ಬರೀ ಸ್ಟೇ ಅಂತ ಅಷ್ಟೇ ಕೇಳಿದ್ರು. ಇಲ್ಲ ನೀವೇನು ಇಲ್ಲಿ ಬರೀ ಸ್ಟೇ ಅಂತ ಕೇಳಿದ್ರಿ, ಡೆಪಾಸಿಟ್ ಆಗಿರೋ ಅಮೌಂಟ್ ಇದ್ರಲ್ಲಿ ಯಾರೋ ಮೂವ್ ಮಾಡಿದಾರೆ ಅಂತ ಬೆಳಿಗ್ಗೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರು, ನೀವು ಕೇಳ್ತಾ ಇದ್ರಾ?
57.1 minutes. There is an earlier hearing application filed by the respondent. I do not have any objection for that.
ಅವ್ರು ಯಾರು ಇಲ್ವಾ? Who are you?
I am representing the petitioner for the 57.
Which matter?
Nisha
Kumar, right?
Nisha Kumar. You are Nisha Kumar?
No, I am not. My senior is representing the case, my lord. That is 57 serial number, so I have to ask for a short.
Sir, an advocate or intern or what is that?
No, no, I got enrolled, my lord. I'm not an intern.
You are not an intern.
But this is my first time I'm talking, so I'm nervous.
No, come this side. You are on your ropes or not? We wanted to check that.
Yes, no, I'm not an intern.
But
It's the first time I'm so it's as if
he is seeking adjournment.
adjournment or
He only has moved it.
like on
As requested by both sides, adjourn list on date.
15 can be.
Minutes may
15
make
after
one
vacation
request
of-
minutes. After vacation, any date minutes, because I need to get ready in this matter. There are 4 volumes.
Date here. A1 of 2025 in MFA 4042 of 2022 should disposed of accordingly. Yes. Yes.
Obliged.
Even non-filing of acknowledgement for having served none appears adjourned. This is non-amendment of. You are for the appellant. You are not amended the cause title of the appeal memo. Okay, adjourned it after vacation only, not process.